delighted to welcome all of you here to the University of Oregon School of Law. My name is Marcilynn Burke, and I'm the Dean and Dave Frohmeyer Chair in Leadership in Law. And we know we have people that are still trickling in, but I want to honor your time and get started. So I am delighted to welcome you to this year's O'Connell Conference and CLE. This annual event is made possible by an endowment established by, established by Oregon Supreme Court Justice Kenneth O'Connell. This generous gift to the law school is how we are able to fund student fellowships and to have a forum every year for the judicial and legal community to examine topics in public policy and law. This year, we decided to focus once again on U.S. Supreme Court cases, given the number of consequential cases in last year's term. So before we turn to the first panel, I do want to recognize judges that are joining us today. And we have several that are registered, and maybe they're online that I haven't seen, but first I want to recognize the people that I've seen in the room. So we have Justice Jack Landau there in the back. Give a wave. And we have perhaps registered but not yet here, Honorable Rex Armstrong. He might be online, so I'm going to call his name. Joel DeVore and Timothy Sercom. And then last but not least, here in the room is Judge Mustafa Kasabai. And we are so excited that President Biden earlier this month nominated him for the U.S. District Court for the District of Oregon. So we're all thinking good thoughts for smooth confirmation waters. So again, thank you so much for being here, and I am going to kick us off with our first panel of the day. So as you know, as we said, the Supreme Court was very busy this last term, and this particular case, SFFA, Students for Fair Admission, presents a lot of challenges and uncertainty for all of us associated with higher education. And so before launching into thinking about the implications of the decision, what does it say and not say, and what next steps we might take, I want to take a moment just to acknowledge the emotional impact of this decision for many people. Many people that have been in the fight for a long time. And for the highest court in the land to effectively overturn 45 years of precedent and say that the goal of diversifying higher education is not compelling, that the goal was not measurable or quantifiable as would be needing to serve a compelling interest, and that racial categories were overbroad and under-inclusive and thus not meaningful. Despite the fact that we know there are deep racial inequities that pervade every aspect of our society, despite the generations of trauma that people of color have endured and continue to endure. So I want to acknowledge that this is a deeply painful moment for many people in this country. So now, today, we have several goals with this panel. One is to provide you with strong substantive grounding in the court's decision, right? All of us did not read how many pages?
A lot.
A lot.
350 something.
Yeah.
350 some, 250 some odd pages. All of us didn't have the time or inclination to read all of that. And so we're going to give you a synopsis of the key points of the case. And then we'll move on to thinking about what are the implications directly to higher education, what are the implications more broadly, and how might we conduct ourselves going forward. I have told our esteemed panelists that I will cut them off if they go over their time, because I do indeed want to make sure we have ample time for questions from the audience. And I say questions. Questions, not speeches, but questions. Happy to have conversations afterwards. We want to make sure we have time for questions. So we're going to start with Professor Garrett Epps. And Professor Epps is a professor of practice here at Oregon Law. And he returned to Oregon from the University of Baltimore Law School. So before he headed east, he taught constitutional law here at Oregon Law. While he was in Baltimore, however, he served 10 years as a Supreme Court correspondent for The Atlantic. His book, To an Unknown God, Religious Freedom on Trial, is a comprehensive history of the Employment Division versus Smith case, which was a 1990 Oregon peyote case. His scholarship is featured in many top law journals, and he received his LLM and JD from Duke. I graduated from another institution in that neighborhood, and his master's from Hollis College. Please join me in welcoming Professor Garrett Epps.
Thank you. I will not comment on institutional rivalries just because I think you've covered that very well.
Yeah.
And I'm going to be uncharacteristically terse, I hope, in this, because my job, as I see it, is just to kind of tease out, I've read this decision now, I think 4 or 5 times. What do I think the court decision means going forward? What does the court actually decide? And I want to start by saying a larger point, which is that this court follows the precise template of what I call a new supermajority, a post-Dobbs decision. It follows the Dobbs plan precisely, which is to do the following. You take established precedent that has been reaffirmed quite recently. In this case, Bakke, Grutter reaffirmed twice in the Fisher case as recently as 2013. And then you deal with it in one of 3 ways. One is, as we know from Dobbs, you just overturn it. You say that decision is trash, it doesn't count anymore. The other is you write that it's already been overturned. No one noticed but years ago. This is what they did with Lemon versus Kurtzman, for example. And then finally, we have this, which has got Chief Justice Roberts' method on it, and that is you don't overturn the case, you just reinterpret it in such a way that it means the opposite of what it meant prior to that. That is to say, after Grutter and Fisher, the court had held that you could have race-based affirmative action in university and college admissions as long as it passed strict scrutiny. The court has now redefined strict scrutiny in such a way that I don't think anybody's ever going to be able to pass it. It expands, and it has the effect of another classic post-Dobbs case, which is to expand the power of the judiciary and the role of the judiciary into new areas of setting policy for the nation. And in this case, at the end of this case, the federal judiciary is now in charge of deciding the goals of higher education. Why do I say that it makes this impossible to maintain? Because the Chief Justice doesn't really say that. Although Justice Thomas, who often spills the beans, says Grutter is effectively overruled in his separate opinion. But what Chief Justice Roberts' opinion is mandate a new court-focused review of affirmative action. Strict scrutiny now means only things that courts can measure. And in fact, he makes it very clear that colleges and universities are not permitted to set educational goals for affirmative action. They can't say we want to train better citizens, we want more fully rounded, he says those things courts can't measure, therefore they can't be used. The measures must be precise, but as Justice Sotomayor points out in her dissent, they can't be too precise because then they become quotas. So it really has reduced the area of operations for admissions offices to almost zero. There's another very important change in the law, and this is far-reaching. It says college admissions are zero-sum, a benefit provided to some applicants but not to others, necessarily advantages the former group at the expense of the latter. And what this means in practical terms is that we can no more think of affirmative action in terms of including previously excluded groups. It is no longer about inclusion. Affirmative action as a matter of law is exclusion. Any race-based affirmative action is unfair to whites. That is the bottom line there. Now, the opinion seems to suggest two limitations to the colorblindness rule, but I think they're both illusory. I think they are false flags. The Chief Justice says, well, the military academies, the Solicitor General says military academies need to use affirmative action because of the national security value of having a diverse officer corps. The service academies aren't parties to this, so we're not going to decide that issue. That's the entire discussion of the national security question in the opinion. But in fact, if you read the Solicitor General's brief, and if you read Admiral Abbott's amicus brief, which is signed by some of the most distinguished military personnel, they raise the issue differently. They don't say this is about service academies. They say we need affirmative action in service academies and in the ROTC programs in the universities that are currently using affirmative action. Because ROTC, actually, the service academies contribute only about a quarter of the officer corps, and the rest comes from ROTC programs. Reducing the admissions of diversity in university admissions will of necessity reduce diversity in ROTC programs, meaning diversity in the officer pool. The court does not consider this point, which was made very clearly by two briefs, even worth discussing. It just blows past it. And I think it's a little bit like some of the other footnotes the court has dropped in time saying, you know, don't worry about Obergefell, we're certainly not going to decide anything about that, that sort of thing. The court reaches its decision by reviewing history. History, or what is called history, is now the sort of standard operating procedure for this court. The selectivity of that history we could go into later, but what that does is remove the court's focus from two other areas that some of us might think judicial craft would require foregrounding a bit more. And the first is the facts. This court is not terribly interested in facts. We had basically, I think, 3 weeks total of trial time in the two lower court cases, an enormous record, expert testimony and so forth. The court really doesn't pay much attention to that. You know, when it does, it sort of misrepresents what the record says, because the court is not looking forward, and the court, this is the second thing, the court is not concerned. It does not concern itself with the consequences of its decision. It is enforcing an abstract rule that it regards as dictated by history, and that's really all that matters. There is the second loophole, the supposed essay loophole, that you can write an essay that shows how race has affected your life and so forth. But if you read the Chief Justice's discussion of that, it becomes clear that if a college wishes to adopt this method of broadening the diversity of its entering class, it is going to be subject to remarkably intrusive discovery and judicial review. Because every essay, according to the chief, has to discuss in ways that satisfy a court race as an effect on that particular applicant's life. Otherwise, it will be suspected that you're admitting somebody just because they are of a race. I think the result of this is going to make adopting an essay program prohibitively costly in terms of litigation for colleges that decide to do it. I will say in the Department of Other Shoe, I see the dean coming my way, that I have in my briefcase the complaint filed earlier this week against the military academy by the plaintiffs in this case, saying the military academy must not allow itself to know the race of applicants. So that indicates that both of that in their view, both of the reservations by the Chief Justice are nugatory, and I will leave it there.
Thank you so much, Professor Epps. Yeah, we can applaud. Thank you, Patty. And we will now move to Professor Stuart Chinn for his opening remarks. He is a professor here at Oregon Law, and he writes and teaches about constitutional law, legislation, and legal and political theory. His book, Recalibrating Reforms, The Limits of Political Change, was published by the Cambridge University Press. Additionally, he has published in peer-reviewed venues, which is not common for law professors, and also in very well-regarded law reviews or law journals. He's a native of Eureka, California, and he received his BA, PhD, and JD from Yale University. Professor Chinn.
Thank you, thank you. So building off of Garrett's excellent summary, I want to offer just a couple of quick observations about the ruling and then say a few words about what might come next and sort of other aspects of the old, now discarded system of affirmative action. So the first is the topic about the purpose of affirmative action. So the winning argument for decades was to focus on classroom diversity. And one could argue now that we are where we are with affirmative action suffering the result that it did in SFFA, that purpose may have been a wrong decision. It's sort of akin to the discussion that comes up in the context of abortion rights, where there were two paths, due process or equal protection. Many academics in the 70s preferred equal protection, but everyone argued due process because that's where the doctrinal precedent was. In this vein, the argument about diversity, this is a long-running critique. Justice Thomas has made this argument for years and years, is that if diversity is the centerpiece of affirmative action, you could focus on other elements of diversity like age or employment or things like that, but most institutions don't care about those things as much as they do about racial and ethnic diversity. This is maybe the upside of the fact that the ruling suffered the defeat that it did with a 6-3 vote, but I think it actually allowed the dissenting justices to be very upfront about what they took to be the core defense of affirmative action. And I think in particular Justice Jackson's dissent articulated strongly that affirmative action is meant to remedy the structural disadvantages of people of color, particularly African Americans. And I think that this, at least in my opinion, has long been the moral purpose, the best moral justification for affirmative action. Understandably, litigators haven't pressed this because this was not a winning argument. The court did not think that this was a legitimate, compelling purpose in Croson back in the 80s. But now that we are where we are, I think having those opinions articulate matters of principle like that is a valuable thing, and getting to the heart of why these programs are important. Second, this is to touch upon a point that Garrett mentions as well about history. So the majority opinion, and I think especially in the Justice Thomas concurrence, lean heavily on the argument that affirmative action violates a principle of colorblindness that is rooted in the original understandings of the 14th Amendment. I don't know if it's a consensus view. I think there's a very strong view among historians who study this that is incorrect, that Justice Thomas's history is incorrect. And indeed, one doesn't have to go far to find where this is incorrect. There's a great deal of legislation passed in the aftermath of the Civil War, particularly around the Freedmen's Bureau, that was all oriented towards benefiting primarily not just those who were recently enslaved, but also African Americans in general, and among them including, for example, the purchasing of the land for Howard University, which was designated to be an institution that primarily served African Americans. And so the history around this, I think, is pretty clear that the framers would have had no problem at all with color-conscious measures to aid disadvantaged minorities. As it turns out in the language, they used the language of colorblindness when it came to prohibiting discriminatory legislation against those minorities, but when it came to matters benefiting their situation, they had no problem at all validating matters of color consciousness. So with that being said about the opinion, let me say a few more comments about affirmative action more broadly. As the students in my class have heard me say before when I've taught these cases in the past, I am sympathetic to the idea of affirmative action, and I've long thought that sort of the best articulation of the rationale of what it is, at least as it has been practiced, and this is something that Justice O'Connor got to in her Grutter opinion, is it sort of spoke to this idea of the value of symbolic diversity within the leadership sectors of American society. There's this really strong interest, an important one, I think, in making sure that our leadership population, our elite institutions, mirror in some meaningful way the population of America more broadly. And I think in the aftermath of this decision, one of the ways to get at that, it won't be as sort of tightly aligned as what race-based affirmative action was, is to focus on things like socioeconomic status. And I can say a bit more about that if there's sort of interest about that. Now, that being said, let me offer a qualm about how I think affirmative action has been practiced, at least in a narrow subset of these schools, which are the highly selective institutions like Harvard University. As mentioned before, the rationale for affirmative action has been on diversity. And if that is your rationale, it does lead to interesting tensions in how the program is administered. And in this regard, I want to draw attention to an item that got reported quite a bit in this litigation, which was the status of the status of Asian American applicants to Harvard University. So, as commentators have observed, Asian Americans as a group consistently had the lowest acceptance rate at Harvard, including white applicants. And there's a 2009 Princeton study that indicated that Asians had to score about 140 points higher than white applicants to have the same chance at elite universities as they did. And this is the part that probably was the most embarrassing for Harvard in the litigation, but they, in sort of the course of going through this litigation, it was clear that Harvard's admissions personnel, they did these ratings of applicants, and one of the ratings was around personality, which measured qualities like integrity, helpfulness, courage, kindness. And Asian American applicants as a group scored far lower than other racial and ethnic groups, although they scored comparable scores when it came to the alumni interviews. So, you know, at worst, this just looks, at best, it looks just a little embarrassing. At worst, it looks like it's borderline intentional discrimination. So what's going on here? And I think the consequence of what's going on here is because the diversity rationale was the rationale. If that is the rationale and you're trying to enhance the diversity of your class, you have to come up with an argument as to why some individuals can't be admitted there. And so, thank you. You have to come up with some rationale as to why some individuals shouldn't be admitted. And so as a result, a way to reject some of these Asian applicants was to talk about things like personality and so forth. Now, to be clear, I don't think a just world is one in which Asian Americans are 50% of Harvard's class. Asians are about 6.2% of the US population. And I don't know that I have a great answer about what the right percentage is. So I say this with some degree of sympathy for Harvard's admissions staff. But related to the way in which this matter of how to think about admissions goes forward, this point was also mentioned in litigation as well, that nearly 30% of Harvard's class was composed of athletes, legacy admits, and the children of faculty and staff. And these individuals constitute about 5% of the applicant pool. So one could look at these elements and think about them as basically affirmative action for wealthier white applicants, which also seems sort of problematic. And indeed, Jeannie Gerson, who's written about this, has argued that there's no obvious reason why Asian interests or Asian American applicant interests should be opposed to those of African American or Hispanic applicants. Rather, one way to sort of balance this out is to sort of rethink the benefit of having legacy and athlete admission preferences to begin with. So anyway, I mention that because, at least to me in reading this opinion, that 30% number was rather outrageous, in my opinion, if we think about the most selective institution historically in America. And in addition, I think this is going to bring a great deal of pressure to these admissions staff to rethink how much they're going to be committed to legacy admissions going forward. Anyway, so I'll conclude there, but I think there are some tensions here that, that continue, and we'll see where the next round of litigation goes.
And Professor Chinn, if I could get you to just say a word about the athletes at Harvard. What sports are we talking about? Because I know we're all looking forward to the Harvard-Yale football game. What sports are we talking about?
Thank you, Dean Burke, for that follow-up. Indeed, so when we think about what these sports are, most who are not paying attention to elite admissions are thinking about things like basketball and football, but that's not what we're talking about in these institutions. We're talking about things like crew, field hockey, things like that. And so we're talking about sports that predominantly tend to have sort of whiter applicants that are benefiting, and also those that are wealthier, because these are sports that usually encompass things like traveling teams, coaching, things like that, that these parents, from a rational standpoint, are thinking are going to help their kids get into college, which it turns out it does.
Thank you, thank you. So next we have Professor Alison Gash. She's a professor of political science at the University of Oregon, and she'll be teaching con law for us next semester. And her research focuses on the intersection of law and social policy, with specific interests in race, gender, sexuality, and disability, particularly in the context of housing, family, and youth advocacy. She co-authored Democracy's Child, Young People and the Politics of Control, Leverage, and Agency. And she is the sole author of Below the Radar, How Silence Can Save Civil Rights. And I'm going to ask you about that book today.
Sure.
And her work has appeared also in numerous law and political journals, as well as the popular press. She holds a BA from Vassar, an MPA URP, I don't know what URP is.
Urban Regional Planning.
Urban Regional Planning from Princeton, and her PhD from the University of California, Berkeley. Professor Gash.
Thank you very much. So when I thought about how I might digest what I might contribute to the panel, I was thinking about it in terms of how I'm going to teach this course, and it was actually a question that was posed to each of us in an email exchange. And, and I teach undergrad courses, and so you have to sort of come at these things from multiple perspectives. And so I thought of like 5 basic things that I found most noteworthy, interesting, eye-opening, worrisome, perhaps, about this decision. And so the first is what appears to be, a really interesting comment about the court generally. And in particular, the irrelevance of precedent, right? When I teach my classes on the courts and my classes on law, we talk about precedent, we talk about stare decisis, and yet more recently, I've been talking about sort of the irrelevance of those terms, and we can see that highlighted really nicely in this decision, the ways in which precedent is smudged at the edges, right? That certain key words of certain key quotes in past cases are erased or altered, right? Garrett mentioned the ways in which things are sort of deployed in ways that suddenly mean the opposite of what they did in the past. And in particular, the irrelevance of context, the ways in which slavery, the ways in which the systems of racism, systems of discrimination, the ways in which structural racism is no longer relevant in the context of these kinds of programs, and the ways in which the historical record, or the historical record that in fact supports the notion that these precedents were in fact tied to those conditions is somehow no longer relevant or no longer true, as Stuart mentioned. And so I think in terms of teaching about the law, suddenly our discussion of precedent and its importance in Supreme Court doctrine becomes a little bit murky, right? How do we deal with what precedent actually is, if this is true? It also tells us a lot about this particular court and the sort of nature of this particular court. And in particular, what seems to be a lack of uniformity in the current court's own precedent, in the current court's own thinking about how it will intervene into the most controversial questions of the day. And so here I want to turn back to Garrett's mentioning of the new compelling interest standard, which now, at least in the context of affirmative action, or perhaps in the context of racial justice cases, needs to be measurable. And yet, we needn't look no further than Dobbs or other past cases to find that there's significant deference given to states and their articulations of a compelling interest. They need to not be measurable whatsoever for the court to suddenly take a hands-off approach and let states do whatever they want to do. And yet in this case, somehow the court is suggesting that it needs to be measurable, and in fact, that it is the court's obligation, responsibility to engage in some form of data analysis or policy analysis in order to figure out what is or is not an achievable compelling interest. And that strikes me as both really interesting when you think about this court's own predilection towards articulating a sort of smaller space for the power of the court, and yet, right, it seems to be suggesting that it's going to take on a lot more responsibility in bean counting what is or isn't in a compelling interest. Which also leads us to what should be some nervousness about what exactly the court is planning on doing, or what data the court is planning on using to figure out whether something is or is not compelling, or whether the state has in fact achieved, right, reaching its goal. And that is the court's shocking, jarring ambivalence, and some would say hostility towards experts, right, hostility towards facts, right, the ways in which, as Garrett suggested, certain key empirical findings were completely disregarded, and then in past cases, the ways in which certain key expert organizations were in fact not just disregarded, but called out and shamed in past decisions. And so it leaves me to wonder how on earth this court is planning on actually measuring these things if certain kinds of experts are deemed to be hostile, right, to the question of constitutional interpretation. It also raises for me a really interesting lens into the life cycle of a court case, right? So, right, we all know that the opinion that a court issues is just the first step, right? It then gets interpreted out in the world by the very advocates that brought the case, by the folks that are subjected to it, and by perhaps the sort of next at-bats, right? So how will admissions committees interpret this, but also how will other folks that engage in some form of affirmative action also interpret this, right? How will they fear the prospects of litigation? And so I want to sort of break these two things down a little bit. So first, I'm slightly, dare I say, hopeful, and that is not a word I use ever. So anyone who's taken my classes knows that I am not a hopeful person in the slightest. And yet I do wonder if, as the court creates more work for itself in apparently reading every single solitary admissions essay and reading all the notes that then go with that admissions essay to make sure that, in fact, mentions of race are, in fact, connected directly to one's leadership potential or what have you, that perhaps this may end up becoming something that the courts are like, I'm out. We can't actually regulate this. And this just becomes sort of a shot into an empty room where admissions committees that actually want to engage in race-conscious kinds of admissions processes can actually create an effective essay program because the actual prospects of implementing what could be an insane amount of work for the courts might just be too overburdensome. And so that's my hope. But I'm also very worried, especially in the context of hiring, which I think is the next battleground. And certainly, right, advocacy groups have already issued complaints and warnings to industries and employers that use affirmative action. And I worry here because the colorblind structures, right, the so-called colorblind structures, the structures that allow for racism to prosper, right, with a sort of thinly veiled rhetoric of colorblindness, those structures abound especially in hiring, right? There are studies that talk about how resumes can be altered, right? So they've done actual studies that change the names of folks that have the same resume from white-sounding names to more racially conscious names, right? Names that sound Latinx or sound, right, African American, right? And we know that the same exact resumes, right, with the exact same substantive information will somehow be rejected when those names are changed towards names that seem more indicative of an ethnicity. And so we know, right, that despite the fact that there are these colorblind structures, right, we know that race matters a lot in the context of hiring and firing and promotion, right? And there are tons of structures that allow it to continue. And so getting rid of affirmative action in hiring strikes me as especially problematic. And we're already seeing the chilling effect of this decision on those kinds of spaces as well. All right.
And now we have Kevin Reed, who serves as Vice President and General Counsel for the University of Oregon. He is responsible for the management of legal affairs at the university, including provision of legal guidance to all university units, schools, and colleges. I am not a lawyer. I just play one on TV. He's our lawyer. His work involves drafting and counseling on a wide array of issues, including promotion of diversity. He previously served as Vice Chancellor in Legal Affairs at UCLA, General Counsel for the Los Angeles Unified School District, and the Managing Attorney for the Western Regional Office of the NAACP Legal Defense and Education Fund in LA. Kevin received his JD from Harvard Law School and his BA from the University of Virginia. Kevin Reed.
Thank you, Marcilynn. I'm delighted to have this opportunity. When Marcilynn asked if I was willing to do it, I thought, oh, I get to sit in a classroom and say, Professor, would you cite the facts in the holding of? And I thought, such great revenge 30 years hence. So I get to bat cleanup and say, so what the heck do we do in this miasma? And I would say that the most important thing that I've been trying to counsel my clients and in my conversations with other colleagues in higher education law is take a deep breath. When the decision came out, I will say that I did breathe a sigh of relief. It could have been a whole lot worse. The things that they did not touch, they did not mention, and frankly, I think you can fairly read, they are not ready to challenge yet, gives us an awful, I believe, a pretty broad swath in which we can operate. I also operate from the lens that I don't believe that there is such a thing as colorblindness, and I don't believe that the majority's opinion is embracing a so-called colorblind standard, despite what the concurring and the dissenting opinions have tried to characterize it. The last paragraphs of the majority opinion that do allow for the consideration of race within context is incredibly important. It is, and I would say, I'm not sure I would call it the essay loophole, or necessarily worry that universities are unable to exercise that. Universities are doing it today. The University of Oregon, in its undergraduate application process, does not use race in any overt way. But we do have essays in which individuals are allowed to describe themselves and how their upbringing, their background, and the experiences that they've had have contributed to who they are and what they will bring to the University of Oregon as an undergraduate student, as a law student, as a student in any of our schools that run their admissions programs. That doesn't mean it's easy. I'm grateful to have had the experience I did at UCLA for 7 years. That is a state that in California in 1996 passed Proposition 209, which forbade the use of racial preferences in college admissions. So I had to watch and help UCLA shepherd its way through a regime in which, no, the readers weren't told the race of an applicant on the screen when they were evaluating an application. But they were allowed to read in an application the holistic nature of what a candidate is bringing. So so-called holistic admissions. It is what University of Oregon's undergraduate admissions team uses. It is what many other schools use. And it does allow for the use and the consideration of somebody who's bringing their context with you. The Department of Education's Office for Civil Rights and the Department of Justice put out some joint guidance in July or August. I'm blanking on the date, giving their interpretation of what the opinion does or doesn't say. And it gave me an awful lot of comfort about the sorts of things that are incredibly important to the University of Oregon in maintaining and advancing diversity, equity, and belonging as being not challenged by the opinion. Our ability to run so-called pipeline programs where we identify at-risk students who may not have been exposed to higher education, and we bring them to campus and show them what it's like to be on a college campus and trying to encourage them to get into the right program so that they are admissible at a university like the University of Oregon. I believe that those remain untouched, and I'm grateful to say the Department of Justice and OCR agree with me on that point. We're allowed to operate cultural centers and support units for marginalized students in our community. So the ARCs that we have in our undergraduate dormitories that support the African American, Latinx, and other communities, I believe are untouched. And I'm grateful to say that Department of Justice and OCR agree with me on that. Our Black Cultural Center, I mean, before the opinion came out, I'm sitting there going, are we going to have to figure out what to do with the Black Cultural Center? And thankfully, I think the opinion leaves that sort of work that's really important to maintaining community, creating that sense of belonging for students who may come from marginalized backgrounds on our campus, I believe remain untouched. Now, I think the biggest question that's out there that universities struggle with is financial aid. Although I would say that it certainly has been my advice here, as it was at UCLA, that any race-restrictive financial aid program is deeply problematic. It was before this decision was rendered, and I believe it's even more problematic today. So I've never been okay in counseling a client that they could have a African-American exclusive scholarship. Can you have a scholarship that otherwise tries to support diversity by bringing an individual to campus who may have demonstrated a commitment to a particular set of values or particular community? Yes, you may do that. And I believe that those sorts of things will remain untouched, although other lawyers representing institutions have decided otherwise. Attorney General for the state of Missouri declared that there would be no use of race whatsoever in their financial aid programs going forward. I will point out that the decision in any of its 200-plus pages doesn't address that issue, and it would be my advice not to read things into the decision that have not yet been litigated. Now, they are going to be litigated. We know that there's a movement out there. Edward Blum, who funded this litigation, has been funding these cases for decades now, is very pleased with the opinion he bought, and he is busy rolling it out across the country. He did send letters to about 150 institutions, including the University of Oregon, saying, here's what the decision says, and here's what you better be doing. All I could say is I'm grateful he's not University of Oregon's lawyer, because I don't think he's right about much of what he said. But he is watching, and it is clear that he will be filing follow-on litigation, as he just did with the military academies, and I believe that they will be going after financial aid next. I don't, and we'll have to wait to see how those cases develop. But I believe very strongly in this notion that we are allowed to and have and will continue to use, and I wouldn't call it a loophole, I'd say it is exactly the core of admissions decisions of a holistic process. And I get a little bit concerned that, I read the Supreme Court's decision, the majority decision, and I realize it's so simplistic sometimes in its reasoning, right? And that notion of, that zero-sum game and how they were focused on that, I get it. It's those arguments that I used to have in college, like, why should the child of a black surgeon benefit from affirmative action? And you can sort of hear that background in the opinion. And I would say, fair question, right? If you are trying to, if you are in a legal regime, which we've been in since Bakke, in which merely creating diversity is not necessarily enough. It's one thing to say, oh, it's the son of a black surgeon, but if that black surgeon's son puts in his essay what it was like to be racially profiled and arrested at going home from a friend's party, and how that impacted him and that's why he wanted to be a lawyer in law school. That's an important message, and something that an admissions team, I believe, absolutely has to take into account. Just as they will take into account the story of the president of the equestrian club at her school about what it was like to lead that group and create that connection with an animal, et cetera. If you don't allow a student whose background is in fact forged by her or his ethnic racial identity and background, then you are effectively discriminating against that individual, because you are saying that they can't bring their whole selves to an application, and that is a position that we'll take as we go forward, and hope that when the litigation happens, it happens someplace down the road and we can learn from it and not have to suffer from it, but we'll see. We are not, at the University of Oregon, we're not afraid of being sued on these issues if what we're doing is trying to press the envelope and make sure we get it right.
Thank you all so much. And to pick up where Kevin left off, and I'm going to call everyone by their first name because Professor gets cumbersome after a while, with respect to how we actually engage in admissions, right, and that all of the panelists talked about the facts that the court found to be irrelevant. And oftentimes in law school admissions, which are very selective, the criticism is that we rely too heavily on LSAT and GPA. And our answer has always been that we engage in a holistic review, that we're looking at everything each applicant brings to the table. And we have, the practices and policies to demonstrate all of that. And yet, that didn't matter. That didn't matter at all. And so one of the things, I am the chair of the Law School Admission Council, and one of the things we're doing is, one, trying to help people calm down, and we've been doing that for a while, but also to look at all of our practices and policies and to make sure that we are not going to run afoul of this pronouncement. So I'm going to turn to Kevin about financial aid. And you used a very careful phrasing there, race restricted.
Right.
Right, and I think about some of our scholarships, for example, and scholarships all across the country, that would say, you know, there's a preference.
Right.
And then usually then it says, or at the discretion of the dean or something, right? We leave ourselves room. So are those scholarships, do we need to revisit those?
Thank you. Revisit them, absolutely. Want to make sure that we are compliant with the law and haven't exposed ourselves unduly to risk out there. But I don't have a problem in the general sense with those sorts of preferences stated. There's a concept that OCR blessed, obviously pre-SFFA decision, but called pooling and matching. So if you've got a overall pool of financial aid that you are trying to distribute, and one of the funds that you have was created by a donor who said that they had a preference for an African American student. When you're distributing money and you are making an award to that student, as long as you are putting, saying those dollars from that fund are going to go to that African American student, as long as you are not excluding others from an ability to benefit from other pools of money, you can be okay. There haven't been many legal challenges to that, but that has been a process that schools have employed as trying to follow through on the intent of a donor who may have established that sort of fund. And then there's complex arguments you could make, and we certainly made at UCLA, that gifts that were made before '96, before Prop 209 took effect, were contractual obligations of the institution, and the state couldn't just shift the law and make us violate those contractual obligations.
Thank you. Now, I have received direction to look at all of the law school's web pages and make sure that they are not saying anything that is now deemed impermissible. When I started at the law school, we were in the process of making broad, grand statements about how we support and are committed to diversity, equity, and inclusion. So I want to turn to Alison, and recognizing her book, Below the Radar, How Silence Can Save Civil Rights, and think about how do we now talk about our commitment?
Yeah. I mean, this is I think where the sort of life cycle of a court case question becomes something that's really important, because the teeth of this court case aren't going to be just created by whatever is in the case, but in fact how it's interpreted by gatekeepers, right? How it's interpreted by administrators, how it's interpreted by lawyers, right, who are watching all of these institutions and seeing, what they're doing, and then obviously by the next judges, ultimately, who are tapped to take these cases. And so, I think on its face, right, when you read the, and Kevin, you should definitely correct me on this, but on its face, when you read the opinion, it seems to me that right, these DEI efforts, especially the DEI efforts that are about the experiences that students have once they're here, that seems to me to be totally untouched by this decision, since this decision is fundamentally about the entrance into and not the experience of folks who are here. So it strikes me that any sort of commitments to diversity, equity, and inclusion that are fundamentally about creating a vibrant, welcoming, safe, compelling space for all students and for all faculty and for all employees shouldn't be remotely touched. And I would argue that we should really hold the line, because there isn't any reason why this decision would, in fact, harm that. That said, on the upfront end, right, in terms of the sort of recruitment materials we put out there, that's, I think, exactly where these folks that are looking for the next case are going to be shining their lens and shining their light, is to eke those out. So, but I don't, I think we should just keep going until told otherwise. But that's just me.
Full employment for the lawyers.
That's right.
So Stuart, Alison talked about how she might approach teaching this in class and how she has talked about it. And I opened with remarks that reflect my point of view and my reading of what has happened. But how will you deal with students who disagree, and how will you make space for that in your classes?
Yeah, I mean, so sort of going back into Garrett's opening comments about the doctrine, the doctrine itself has been such a confusing area since beginning with Bakke, and so there's a part of this that just is about sort of the technical nature of what these opinions are. That's certainly important, right? And I say this to my students, no matter what the controversial subject is, no matter what your position is, you need to know what the right language is to advocate for it and to know what the plausibility of those arguments will be. So that's a starting point. But beyond that, to make room, I think, for the articulation of sort of different policy beliefs, articulations of what the purposes are, whether those are strongly in favor or opposed. At the end of the day, the issue's not going away. So we're all going to have to continue talking about it for better or worse. And so I would hope that no matter what the position is of my students, they at least have the right tools to be able to advocate responsibly in that space.
Absolutely. Garrett, you said you had the case in your bag, and so I won't ask you questions specifically about the case, but as you know, there was a military exemption in this case, and now West Point has been sued. But tell us about the military exemption and the significance thereof.
Well, but the history of this is really fascinating.
And if you could speak into the
Yes,
mic.
even into the mic. The history of this whole matter of how military and national security concerns get stirred into this, what seemed at the time domestic question of policy. Interestingly enough, dates back to the Grutter case itself, and to an intervention in the case by then still living, former President Gerald R. Ford. Grutter, of course, had to do with the University of Michigan. Ford knew a lot about that part of the Midwest. He got together with some of the retired military brass that had served with him while he was president, and he said, guys, if I understand what you were telling me back then, this is really going to be really bad for the services if we can't move to keep desegregating, in essence, our officer corps because of what happened in Vietnam. And of course, at that time, these were people whose memories of what happened in Vietnam were very, very vivid. The intense racial hostility, the rioting, the prison riots. When you read the accounts of what happened in the military in Vietnam because of tension between the white officer corps, 2%, and 30% combat force that was non-white, you realize that the military had been very badly burned by this and had spent a lot of effort trying to rebuild unit cohesion. And he said, the court needs to know about this. And this was a very famous brief that was filed by retired military officers in the Grutter case and is cited at length by Justice O'Connor in her opinion, basically reaffirming the Bakke principle on the grounds that this is very important for national security. Come forward to this case, precisely the same sequence of events occurs. The Solicitor General files a brief, which has 2,000 words about the national security implications of, doing away with diversity in higher education. It goes in detail about the military academies. It goes in detail about the ROTC programs. And it discusses the military experience in Vietnam. And then Admiral Abbott and 4 or 5 former chairmen of the JCS, 3 living Medal of Honor recipients, files an amicus brief like the one in Grutter, which the court doesn't really see fit to mention. And if you read the complaint in the case, which is now called Students for Fair Admissions versus United States Military Academy, they basically deal with this by presenting what I will call, for lack of a better term, alternative facts. And they basically say that there really has not been a history of racial division in the military. There were a couple years in Vietnam where things were bad, but they all got better right away. And the races have served harmoniously, and what enlisted personnel want in their officers is merit and character, and they don't care about mere skin color. And whenever you hear the word mere skin color, you need to examine what's being said, right? Because I really don't think that's the implication of this national security discussion. And so they are inviting the court, in essence, to set aside and substitute this alternative narrative. And they say, as a result of that, we cannot, and they say precisely the same psychological framework that the opinion in the fair admissions case has in the Supreme Court. The Supreme Court says, oh, well, you know, the universities say, trust us, we're using this responsibly, but we don't trust you. You are not worthy of trust. Only courts can be trusted. And they take the same approach toward the military chiefs of staff and say, yes, they say all these things. But, you know, of course they say that. They're bureaucrats. They want to do things the easy way. You know, we can't trust them. They're just, you know, they're the deep state. They're, you know, whatever. You know, pay no attention to them and stick with the idea that only colorblindness produces merit. And the interesting opening sentence of the complaint says, for most of its existence, the United States Military Academy has selected and evaluated cadets on merit alone. It then goes on to say that changed, you know, 30 years ago when they began doing affirmative action. And I went back and took a look, you know, in the first 70 years of the United States Military Academy, it graduated 1,100 graduates, of which 3 were African American. If that is the picture of merit that we are being directed back toward, will this, you know, is it likely the Second Circuit will buy this argument? I would say probably not. But I think it shows the kind of offensive use of this precedent that's going to be done in a lot of litigation. I mean, we've got a really kind of stochastic situation in our federal courts now where we have widely polarized judges at the district level. And what they need is to get a couple of decisions that are pretty extreme at the Court of Appeals level, let's say in the Fifth Circuit. And then the Supreme Court has to step in and we'll have to resolve this. And I was actually really happy to hear that you were hopeful.
I'm never going to say it again.
My view of this court is based on an old verse by Bertolt Brecht, the German playwright, who said, the man who laughs has not yet heard the terrible news.
Wow. That. But I am going to pick up on a thread there. Merit. And this is a toss-up for anyone. Should we be talking about merit differently? You know, we got color blindness, we got merit. How might we frame this discussion differently?
I'll bite. Yes, I mean, yes, I think the answer is yes. And so if I assess the panel correctly, I feel there's a little bit more hope from Kevin and Alison, a little less hope from Garrett. And so to insert myself, I guess, on that spectrum. I mean, I think Kevin articulates his experience in California, the go-to playbook of what happens when you can't do race-based affirmative action, holistic review, which California didn't have until after, before then they actually had a limit on sort of how much that could occur. Outreach, for sure. And then not in California, but Marcilynn might have experience with as well, what you saw in Texas, the top percentage plans. Those are go-to options to think about how to rectify disadvantage on socioeconomic indicators. It's not going to be as good as race-based affirmative action in terms of getting diversity, but it is something. I think that is a way to sort of start thinking about how to think about this problem about merit more generally at these selective institutions. I actually find myself deeply troubled by the level of inequality on class components as well, and I recommend the work of Raj Chetty if you haven't looked at it, but this is getting a ton of press coverage as well, just seeing how much the children of the top 1% are concentrated in these Ivy Plus institutions. To Garrett's point, I share his pessimism on this regard. At these really selective institutions, how they actually, so this is I think different than the story of what would happen at a large public, but at these highly selective institutions, how they choreograph the construction of a class I think is a very, very delicate thing. And they were able to do this with a high degree of discretion before there's opinion that they can't do on the other side of it. And so that's a real tool I think that's lost for those institutions.
And I'll just add to that briefly. I agree that we do have to rethink merit. And the SAT is a phenomenal predictor of household income. Whether it is as an accurate prediction of somebody's ability to succeed in college is I think, questionable. No offense to my friends at the College Board. What I often am advising clients when they're asking me, like, how can I define what I'm looking for? If they come to me, example, comes to me, they want to establish a scholarship for Arab women filmmakers. And I was like, okay, because you want that voice in the room, right? And so I said, how if you establish a scholarship for individuals who've demonstrated the ability to express the Arab woman's experience in film? And that worked in my view, and is defensible. Again, you've got to be careful that you are not engaging in what the majority opinion cautioned about, essentially using proxies as a workaround to accomplish an end that they've forbidden you to accomplish. But I really think the exercise is describing what is the result you're looking for. Is the result looking for somebody who got a high score on a test, or are you looking for somebody that's adding something of character that is not related directly to their race and ethnicity, but may have in fact helped been essentially incubated by that?
Thank you for that reference to the SAT, because that gives me an opportunity to talk about the LSAT. And there are much better correlations between the LSAT and GPA from undergrad in predicting first-year grades in law school. And then those grades are good predictors of cumulative GPA in law school. And then the cumulative GPA is a good predictor of whether or not one will pass the bar on the first try. Now you might say whether or not you pass the bar on the first try is not a great indicator of whether or not you'll be a great lawyer. But that's a whole nother panel. Know that those are some differences that when people start talking about admissions tests, there are quantitative and qualitative differences among the tests. So I want to be true and say that we're going to now open this up for questions from the audience. And Jennifer Geller is the roving microphone, and I got her right down here in front.
My question is, who gets to decide what is merit? You have a district judge, I can't remember, I think it's in Virginia, who's decided that high-level performing high school in a school district must use grades, and that a lottery discriminates against white people. So he's determined that only grades can determine merit. Where do you think that argument's going?
I'll say historically, this is, my head's really, so this is going beyond the law and sort of thinking about this even sort of sociologically. Historically, the answer to this has come from these admissions staff. It's these institutions, right? So common elements of what it looks like in these, so Yale admissions, my alma mater, right? They probably take into account things like geographic diversity. They take into account things like personality. They used to actually make people submit photographs as well and take physical measurements. That was sort of how they thought about merit, right? Over time, institutions are sort of functions of society, so those conceptions will change. My very tentative view about this is, I don't think institutions are well served by having the federal courts come in and dictate what encompasses merit, given the things that we've talked about historically in these cases about academic freedom and the need for institutional autonomy. At the same time, I think there is an obligation on institutions to come forward with the criteria of merit that seems fair to the broader populace. And so I don't exactly know what the dialectic looks like, but I think that's what's called for.
I do want to state the caveat that if that federal judge is Kasubai, it's probably going to be okay. I would say that it is one of the things that bothered me about the decision in June is it's ignoring academic freedom, which I do believe is where merit needs to be determined. The institution has to have control over who it admits to his course of study, what qualifies one towards a degree at that institution, and fundamentally I believe those things belong to the faculty. And I do believe that institutions of higher education have got to work very hard to empower faculty to have a voice in how those things get determined.
I'll also say that from listening to the oral argument, reading the briefing and other material, it's very clear that one of the aims, and it's only one of the aims, of the anti-affirmative action movement is basically to have the courts outsource the determination of merit and admissions to them. And SFFA submitted several plans that it said Harvard should adopt. And it said, we have prepared a plan that Harvard should adopt for its admissions, and it'll produce satisfactory results. Here are the figures. And you know, of course, the court did not go quite so far as to say, we order you to make Ed Blum the director of admissions at Harvard. But that's the aim. The aim is to freeze a certain consideration of merit. A lot of it centering around numbers, right? The numbers have this strange hypnotic quality on people. And, you know, the GPA, the LSAT, you know, may mean X or it may mean Y, but to a lot of people, 2 points on the LSAT means a lot. And whether that's right or not.
And statistically, it doesn't.
Yes, exactly. But you know, that it has that effect on
It
people's
does.
minds. And so I think we need to be careful about an attempt to numericize merit, if you want. I think that's something that will be going on in the discussions as we go forward.
Right, and I think that point that Alison made about, you know, watching judges plow through admissions files, and that we don't assign a number to anything, right? That we're looking at a multitude of factors, and one thing may rise to the top as being most significant about a particular application versus another application, it might be some other factor. But I think one thing that we will do is to be more explicit about all of the things that we're considering in the review.
My question is a little bit about public opinion. Recent research came out, I know the New York Times reported on it, that the public perception about college and the value that it provides for students, they polled parents and students alike that the value that people are seeing in college has dramatically dropped over the last few decades. People don't see the value of going to college anymore. I'm curious about what your perspective is, this opinion and the impact on that broader perspective about the value of college. I think some research have cited that this drop in value seen from the public is sometimes coming from the conservative value that they don't feel accepted at a college. And I'm curious if this decision and what your perspective would be on that percentage moving forward and how we can build back up the value of going to school, both from an undergraduate and then into further degrees in the future.
Anyone want to take that, or you want me to take it?
Yeah, all right. I'll chime in really quickly so Marcilynn can chime in. I commend that op-ed, actually. It's by Paul Tuff, I think, who also wrote an excellent book called The Inequality Machine. I think those issues about the broader view of higher ed are sort of related to this, but go beyond that as well. I think it is incumbent upon institutions, not just on the issues we're talking about, but beyond that, to articulate the value that they serve to the broader community and why they are a value or a place for all individuals, no matter the ideological orientation. The other component as well, which I think that op-ed mentions, is the cost component, and that's like one of the enduring issues across all of higher ed today, is how to make higher education affordable. I mean, that's a really, really big one too.
I would only add, I don't know how much this decision might impact that. It's not lost on me that affirmative action is profoundly politically unpopular in this country. Even in California, an attempt to repeal Prop 209 a couple of years ago lost badly at the polls in a very blue state. And all public opinion research shows that people don't like the idea of affirmative action phrased as such.
I would just say, I think that those data points are interesting. I do feel they likely are wrapped up in COVID, right? Because perceptions of higher education took a huge hit during COVID when, 2.5 years of student education was online and, with varying degrees of success. So, the sort of what those data points represent, there's a question mark there. It's also a function of a very, very, very strategic and successful campaign on the part of especially conservatives to essentially question the value of education writ large, right? And that's been happening over the last 2.5, 3 years. And so I think part of that is also those numbers are a function of that as well, right? So the degree to which higher ed necessarily needs to even pay attention to that at all, I don't know, right? I think higher ed needs to keep centering, right, students and centering student achievement and centering student voice, and if it does that, then it's good to go.
Right. To chime in, obviously I think higher education is quite valuable given my line of work, but I think one of the things that also became more evident and pronounced during the pandemic was the concern about tying college, undergraduate education, to the world of work, right? And so parents wanted to see that their children were learning something that was going to help them start off on their way into adulthood. Now, at law school, we've been quite concentrated on that for quite some time. Professional schools, we're very much concentrated on career readiness and helping our students to find jobs, right? That's the case across professional schools. And I would say that I am delighted to hear our new president, John Carl Schultz, articulate that as one of his early priorities, is looking at how do we tie what's happening in the classroom to the world of work. And that's whether or not the types of things we do in the classroom change, as we have in law school with more experiential education, or whether we help our students understand and we help employers understand. I will take my own major, interdisciplinary studies. What does that say to a potential employer, right? So being able to articulate what are the skills that you are bringing to the table. We haven't done a very good job about that. To say that someone who is a good writer and good in analysis and those sorts of things. So I think part of it is that seeming disconnect, and that colleges and universities are now getting more serious about that. We track our students at the time of graduation. What is their employment? 10 months later, we ask, what is their employment? And so in law schools and professional schools, we've been very serious about that, not as much at the undergrad level. So, do we have any other questions from the audience? One last one.
So I've seen a real uptick in the talk about maybe getting rid of legacy admissions at the elite schools. Do you think that would actually ever happen in the wake of this, or do you think it wouldn't?
So to that point, right? I think they're getting pressure. I think they're getting pressure in a way that they haven't before. It also was mentioned that Dear Colleague letter as well, that schools might re-examine whether they want to continue to do it. They're highly unpopular, right? 75% of Americans polled think these are not legitimate considerations for college, and yet the history of some of these schools, and I go back to my alma mater, when they just try to reduce the percentage of prep school kids, they got enormous blowback from their alums. They had to moderate. Those schools are chasing dollars, right? And so they've got real incentives not to do it. My suspicion would be they're probably going to tinker with it, would be my guess, but I feel the pressure would be too heavy for them to get rid of it. That's my guess.
There's a couple of four-year colleges, liberal arts colleges, that have already done that. And so we will have the opportunity to see what happens with them. Aside from that, I don't know.
And Hawkins doesn't have it too, I think. So, yeah.
Right. And I think even with those statements, the fact is that those children have tremendous advantages. So whether or not you're explicitly recognizing the legacy, we also know that they have had different opportunities, different networks, and so it'll still have an impact on admissions. But whether or not it explicitly you get an extra check on your admissions file, we'll see. Only time will tell. So I want to thank our panel and all of you for being here. And I want to close with this thought, and it's both hopeful and worrisome, to take Alison's frame. A friend of mine, she's a professor at Loyola LA, Professor Kimberly West Falcon, and we were on at a panel together a couple weeks ago, and she described these cases, this line of cases that Ed Blum and his ilk, his people, are bringing as a Trojan horse. All right. And, you know, she talks about how Ed Blum, he searched for 2.5 years to find Abigail Fisher because he wanted to go after the University of Texas, right? That was in his sights. And so it seems as if, right, and you remember the story of the Trojan horse, right? The Greeks were losing the war, 10 years, it was horrible. They said, okay, we surrender and we are offering you this gift, this beautiful horse. But you're gonna have to let down all of your defenses in order to accept it. And they did, and then of course there were soldiers inside the horse, and that's how they took Troy, right? So this seems like a gift. It seems like we want to treat people equally, that color blindness is in fact something that we should be chasing. But as our panelists have discussed, in the ways and the implications that this will spread, whether it's with financial aid, whether it gets to hiring or the provision of services, that this indeed is a Trojan horse. I am hopeful because of these people. I am hopeful that we will find a way to continue to press on and figure out a way in which we can express our values and to demonstrate what is truly important to us. And at the same time, I'm not so naive to know that there are hundreds of soldiers running around filing lawsuits every day. And Kevin Reed said, we're not afraid to be sued for doing the right thing. Thank you, everyone. And we'll get ready for the next panel at 2:30.